In today's video, I want to take a look at year-end bonuses, that is, employment contracts, employment law, and the entitlement to a year-end bonus. Year-end bonuses can be a problem area, an area of fairly hot contention and dispute between employer and employee. So the sort of questions you need to look at in the first instance, whether you're an employee or an employer, would be essentially, is the employee entitled to a bonus? So the first thing you'd look at would be the contract of employment. Is there provision in the contract for a bonus? If so, how is it to be calculated? Perhaps it's not in the contract of employment, perhaps there's reference in the staff handbook. If a bonus is payable, is it at the discretion of the employer? So do specific goals or targets have to be met, or does the employer have complete discretion in relation to the paying of the bonus? Another question to be looked at would be, is there custom and practice of paying a bonus with no reference to a particular standard of performance or goal achieved? If that is the case, if there is a custom and practice built up, it's possible to imply a term into the contract of employment, even though there may not be an express term, that there is an entitlement to a bonus. Rows also happen in relation to departing employees. So as you can see on the screen there, the Labour Court in that Bord Gáis Energy Limited versus Thomas case held that the employee was not entitled to a bonus because the company rules said the employee must still be in employment with the company. So an employee may well do the work and reach the targets and have accrued an entitlement to a bonus, but it may be a rule of the company, it may be in the staff handbook or indeed in the contract, that the employee must be still in employment. However, would this decision have been different if the rule was not set out in the contract of employment or in the staff handbook? From the employer's perspective, it's important and advisable to make it crystal clear in the contract or staff handbook that any bonus payment is made at the sole discretion of the employer and will depend on the performance of the business and the performance of the individual employee. The High Court has from time to time had to decide on disputes in Cleary and others versus B&Q Ireland Limited. This was a judicial review against the decision of the Employment Appeals Tribunal to uphold the employer's right to withhold a summer bonus from the B&Q employees. The High Court held in favour of the employees because it noted the right of the employer to have discretion regarding bonus payments, but also noted that that discretion must be exercised reasonably, and in this case the High Court held that the discretion to withhold the bonuses was not exercised reasonably, and therefore the employees won the case. The High Court also in Finnegan versus J&E Davy makes the point that the plaintiff could reasonably expect, as a matter of principle built up from a number of years of consistent conduct in the payment of bonuses and the matter of discretion never having been mentioned to him at any stage, that some bonus would be payable. In other words, this is the custom and practice arrangement again, no mention of discretion, no mention of particular targets. There appeared to be a custom and practice built up, and therefore the employee was entitled to rely on that as an implied term in the contract. In conclusion then, bonuses can lead to disputes and a sense of disappointment, a sense of jealousy. Clarity in the contract of employment or in the staff handbook will help to minimise friction and rows between employer and employee. I hope you find this video useful. If you do, you might give it a thumbs up down below, and my contact details are there on the screen.